Happy New Year. So we're going to get started. As I typically do, I'll give you an update of what's happened since the last time we were together, and then I will field questions. I do want to let everybody know I may get a phone call during this, which is a call I have to take. So I apologize in advance. It'll be maybe a 5 to 10 minute phone call, and so if I have to step off the stage for that, I apologize. All right. So we are here. We're in February 2020. Couple of things that you should be aware of that are going on at this point with regard to the federal litigation. The parties, all of the remaining parties, have entered into a stipulation regarding what's called limited discovery. So the judge asked for issues regarding ERISA and the plan's application under ERISA at certain dates and times for there to be discovery on that very specific narrow issue. In addition, we have, myself as well as the other plaintiffs, have filed a motion for summary judgment with regard to count 4 of the complaint. Simply put, summary judgment is basically telling the judge that there are no facts in dispute. All the questions at issue are questions of law, and a judge can answer those questions of law. We don't need to have any testimony or anything like that. So while our motion for summary judgment on count 4, which is the ERISA count, is pending, the parties entered into a stipulation regarding limited discovery on that narrow issue. That discovery, the stipulation entered about 2 weeks ago. There hasn't been anything that's been circulated by any of the parties yet, but I expect that that'll be happening very soon. Discovery would be requests for documents, possibly depositions, interrogatories, questions to the various parties to try to get information regarding that ERISA issue. So that's what's going on in federal court as of right now. I'm sure, because it's usually asked, there have been no active settlement discussions with any of the parties since the last time we were together, and it's been quite some time since we've had any active settlement discussions with the parties. In addition to that, all the money from the Charter Care Community Board, St. Joseph's Roger Williams settlement, that has come in, and the money from the Charter Care Foundation settlement has come in. So that's Settlement A and Settlement B. The total cash portion of those funds, gross cash portion of those funds, was somewhere in the vicinity of approximately $18 million. The net funds, so after payment of Wisto, Sheen and Lovely's fees, increases the plan balance from what it currently is, $67,400,000, and increases that by about $12 to $13 million. So that puts us at about $80 million. And if you recall, when we started this over 2 years ago, we were at about $85 million. So those two settlements have put us back, almost reset the clock back to the August 2017 date, which is a good thing for all of us sitting here because it extends that runway for us all. Excuse me. We continue to communicate with the federal agencies, Department of Labor, Pension Benefit Guaranty Corporation, as well as the IRS. They continue to get all pleadings and communications from us regarding what's going on here. So that is an ongoing process. Although there has been nothing definitive with regard to any position that we take with regard to whether or not the plan was in fact a church plan, when it ceased to be a church plan, and ERISA from any of those agencies. So we continue to keep them apprised of the efforts, continue to send them pleadings, but there have been no discussions with regard to the position that we've taken as to the plan's effectiveness under ERISA versus a church plan. One last significant event that occurred since the last time we were together is that the old hospitals, Old St. Joe's, Old Roger Williams, and Charter Care Community Board, a liquidating receiver was appointed for those entities. Attorney Tom Hemmendinger, who's an attorney that I've known for a long time and who does the same type of work, was appointed by the court as the liquidating receiver, and it is Tom's job to wind down those entities. They were in wind down mode already. Attorney Rick Land was representing those entities and winding them down. And at this point, it became apparent that it was more appropriate to have a liquidating receiver to do that job under the control and guidance of the court. And so that's what happened. Sometime in, I forget the exact date, but it was mid-December that Attorney Hemmendinger was appointed as the liquidating receiver. What's important for that for us is a couple of things. One, he assumes the obligations of those entities under Settlement A. So as you might recall, Settlement A, the settlement with the old entities, was not only a cash portion, but it was assignment of certain rights. For example, the 15% interest in the Charter Care CCCB joint venture, which is the hospitals. There's a put, which I'll talk about in a second, that needs to be exercised or not exercised. And Attorney Hemmendinger now steps into the shoes of those entities and now holds all of the interests that were transferred to me, to you, via Settlement A, and he holds those for this estate's, your plan's beneficial interest. So for the most part, with regard to those issues, for lack of a better way to put it, he takes direction from me as to how we're going to proceed on that because he holds those assets for us, and the value of those assets will ultimately benefit the plan. The other important factor on that is this plan is one of the, if not the most significant creditor of those companies. So to the extent that that estate has any money at the time that it is wound down, the majority of those funds, arguably, it's our position that it is not arguable, but I'm sure there will be others that will argue with us, that the majority of those funds will come into this estate as well. So if there were, say, $1 million at the end, I believe that based on the percentages, and don't hold me to these numbers, we'd be looking at approximately 90 to 95% of that pool of money to come into this estate. So that's the second benefit as a result of a liquidating receiver going in. Under the guidance of the court, winds those down, and then whatever money is left over gets distributed pursuant to a claims process. And this plan would be the primary beneficiary of those funds that get distributed. So that's a significant event for not only those entities, but also for the plan. It doesn't affect the settlement in any way in terms of having the ability to set it aside or change it or anything like that. The judge was very clear in the order that the liquidating receiver had all the powers that a liquidating receiver had, except when it comes to the settlement, he had to step in the shoes and comply with all the obligations and holds that interest for this plan and takes direction from me. And the other beneficial piece is that it's the same judge. So Judge Brian Stern, who's overseeing this receivership, is also overseeing that receivership. So there's no chance that anything can happen in one hearing or one court versus the other that would be adverse to one or the other, because it's the same judge handling it. And I will tell you, Attorney Hemmendinger and I, since he's been appointed, have met with the judge together on a number of occasions to talk to the judge about the various issues. So both he and I are also looking at this as a cooperative effort where we're working together on it. I did just mention to you where the plan's assets are today. And that number, the $67,400,000, was as of the end of December. So the money for the CCCB and the CCF settlement is not reflected in that number, which is why I told you add that to it and we get up to the $80 million number. With that, unless you think I forgot something, I don't believe I did. I don't think I did. With that, I will open up the floor to any questions. I will tell you that I have not discussed with Attorney Hemmendinger whether or not he is going to create a website similar to mine, where he puts all court filings up there so that anybody can see them and download them. This is not the call that I was waiting for, unless the call is potential spam, but it's not the call I was waiting for. So I don't know if he's going to do that. I will speak to him about that because even though it is more of a tangential issue for us, it is something that is relevant to what we are trying to do here. So many of you may just at least be interested to see what's going on there. If he does not have the ability or the desire to post them, then what I will do is I will probably coordinate with my office so that we open up another drop down, which is related to the liquidating receivership. So that's on my website for you guys to access. With that, excuse me, with that, yes.
So what about the court order? That's totally aside from this?
Which court order?
15%?
Oh, you're talking about the put? So the exercise for the put, so the put is the 15% interest in the joint venture Prospect Charter Care Community Board. And that put originally was supposed to be exercised in June, and as you know, we've pushed that date back several times. The date is now, I believe it's February 10th. There is a triggering event that will occur on February 5th. Where if Prospect doesn't provide certain documents by the 5th, we have an automatic right to extend that out again. I will tell you, as I stand here right now, that has been a very constant and intense discussion between myself, attorneys at Wistow, Sheen and Lovely, and Attorney Hemmendinger, who holds that interest for our beneficial interest here. And as I informed the judge at our interim report last week, while I am leaning strongly towards exercising that put, I have not yet made a decision as to whether or not that's in the best interest of the plan. So while it's likely to happen, I haven't decided that it will. I can tell you that I am happy to report that Prospect and I have sat down, and there are some provisions of the LLC agreement that require appraisers and certain qualifications and things like that. And we have sat down and we have been able to come to an agreement to essentially, for lack of a better way to put it, modify the requirements under the LLC agreement. They were a little unwieldy, didn't make a lot of sense. And rather than hold to the strict language that was in that agreement, Prospect and I have agreed to modify it. I have engaged an appraiser. I actually, along with the old legacy hospitals, when Rick Land was representing them, engaged an appraiser out of California. And Prospect has already acknowledged that that appraiser qualifies under the agreement. They have just provided me with the name of an appraiser that they would like to use, and I'm waiting for some confirmation on certain aspects of their qualification before I am comfortable accepting theirs. But at least it's positive in that Prospect has said they want to move this process along and that they are agreeing to modifying the process in a way that makes practical sense rather than sticking to the literal language of an agreement that does not really make a whole lot of sense. So we are making progress there. That said, your question is whether or not what's happening with that. As of right now, nothing. But by the 10th, you will either know that it's either exercised or not, or we're going to extend it for another period of time while we continue to evaluate whether or not it would be beneficial to you for me to exercise that.
So why would Prospect be suddenly sort of turning over a different leaf on this and wanting to move it along?
Good question. Question that we've all asked. The question is why would Prospect all of a sudden be cooperative with us on this point and want to move this along? There are a number of reasons why they could, but I don't have any insight into why they are. I will say that we have been suspect of that, but I go on the premise that just because they want it doesn't mean it's bad for us, although at the same time, just because they want it doesn't mean it's good for us, which is why we continue to evaluate, and I haven't actually exercised, or Attorney Tom Hemmendinger has not indicated that there's a desire to exercise that put. So we're still evaluating it. This is litigation, so we're always looking for why somebody is doing something that they are, what appears to be cooperative or not. So it's certainly a question we have asked and we continue to ask, and we may never know the answer, but our actions may give us a little insight in the way that they react to what we do.
So would the evaluation be done by the people that you like from California and their person, or it would be one or the other?
Yep, so the question is how will that evaluation be done? Under the LLC agreement, the way that it works is that we would retain one expert appraiser, they would retain one expert appraiser, and those two appraisers would select a third. The three would do their respective appraisals, and to the extent that they're all in line, then the appraisers will come to an agreement on what the value should be based on their own personal appraisals. To the extent that there's an outlier, that appraiser is kicked out. So if there are 2 out of the 3 are, and I'm just going to use round numbers, if 2 out of 3 say that the hospital's worth $100 million, and one says it's worth $50 million or $150 million, that appraiser goes away because it's not in line with the other 2. If you get them back and one says 90, one says 100, and one says 110, obviously that example lends itself to 100 million. The appraisers would get together and say, okay, this is what we think the value is. But that's how the process will go. And the discussion just today was about how we would go about selecting the third appraiser. So we've got ours. I'm going to assume that theirs is qualified in the same way that ours is, but I haven't seen the information to confirm that. And assuming it is, they would find somebody that they both agree is equally qualified to do the job.
I know I missed a couple of meetings, so we probably discussed this before. What about the diocese? The reason I'm asking, I was watching television about 3 weeks ago, and the bishop was on, and they were asking him when his retirement would be. And he said 75, I think he said he's 73. And to me, that meant he's going to milk it probably till 75 and plug out.
He very well may. The question is, what about the diocese? All I can tell you is that our communication with the diocese has been limited to negotiating terms of the stipulation and consent, unlimited discovery, and things of that nature. The diocese has not approached us in any recent months with any ear towards or eye towards any negotiation. So as far as I am concerned at this point, we continue down the road of litigation with the diocese, and if settlement is possible, it's not because of any discussions that have happened thus far.
I think we can expect the church plan issue to be resolved.
That's a very good question. That's a difficult question. The question is when do we expect the church plan issue to be resolved? It could be resolved as quickly as our motion for summary judgment. If Judge Smith, who's going to hear that motion for summary judgment, determines that, in fact, summary judgment is appropriate, that there are no questions of fact, and it's really just a question of law, and that he believes it's appropriate to rule on that motion and grant it, then that probably will resolve the issue, if not a large part of that issue. Barring that from happening, that's what the discovery is geared towards, and then that's also the reason why we continue to send the PBGC, the Department of Labor, and the IRS the pleadings in this matter, and all communications in this matter, because that's an issue that they are going to have to, if the court doesn't resolve it, that's an issue that those agencies are going to have to resolve. One way or another, either Judge Smith is going to have to make a determination as to what he thinks based on the information before him, or those agencies are going to be forced in one way, shape, or form to address the issue. It's very difficult to say. Has our motion for summary judgment been scheduled, docketed? So our motion for summary judgment hasn't been docketed for hearing yet. And the discovery hasn't yet begun. I mean, it could be, as quick as 6 to 9 months, but it could go on much. Limited discovery doesn't mean fast. It just means we can't ask for more than on this issue. But that could be a long time. Keep in mind, we've got a number of defendants, non-settling defendants. So they're all going to want to do their own type of due diligence and review into all of this, and then we obviously have a number of defendants that we're going to be asking questions of and information from in deposition, so it could be a while.
have to give us money because
The
people are responsible, or would they be for anything?
So the question is if it's determined to not be a church plan, would the diocese be more liable or responsible? Correct? Unfortunately, because we are in the midst of litigation, I can't answer that question. I believe that the remaining defendants are all liable for the problems with this plan that we've raised in the complaint. And quite frankly, at this point in time, I can't, and I don't think it would be appropriate because of active litigation to weigh in on who I believe is more or less liable, if anybody, except to say that it doesn't matter to me who pays the money as long as this plan gets it. So whether it's the diocese or Prospect or Angel or any combination of them, it does not matter. And at this point, it's too premature, and we are in the midst of this where I can't answer that question. What I can tell you is the settling defendants have, I think, satisfied their obligation because they've settled. So whatever that is, that's been taken care of.
As people are retiring now,
This is also not the call that I was expecting. Go ahead. As people
that are retiring now, are they able to get their pensions now? Or?
Yes. So if anybody who's in the plan is closed, so the number of participants in the plan exists as of today. If you become eligible to receive benefits under the terms of the plan, either under an early retirement or a standard retirement age, you make your application for those benefits, and those benefits will be provided based on the calculation that's done by the actuaries and what you're entitled to. What do you mean the time?
But from the time that you applied for your retirement and from the time that you received your first check, what would you think?
I don't know exactly. Julie, do you have any idea of the time frame between applying and getting a determination? Several months. Okay. So apparently between the time that you apply and the determination of what you're eligible for is several months. Once you get that eligibility, it's my understanding that you have to elect the benefit that you want to collect. And if you don't make that election, then no benefits come until you actually do. So some people don't make that election right away, and they just hold on to it and wait. They want to see what they're going to get, and then they kind of wait to see what happens. But from the time that you make the application to the time that you get a determination of what your benefits would be calculated at, it's several months, assuming all the records are in order. There have been a number of participants who have applied, and the records of their employment are either lacking or they have to be researched in some storage facility because they're archived because they were so long ago. So that obviously adds to the delay if we can't identify records to accurately reflect employment for people. Yes.
Where are we applying to for the,
I'm sorry,
where do we apply for your pension?
So GRS Consulting is the actuary for the plan today. And if you come up after the meeting, Julie has contact information for you where you can contact them, and they will give you the information that you need to start your application process. That's not my phone. Any other questions? Bless you. I know that, I guess I'll say this, is I know that this, we've been at this for more than 2 years now. And it's definitely a long haul. And I know it seems that there's not a lot of progress that has happened, although we did settle out and receive about $18 to $20 million in that time. Unfortunately, this is the world that we live in terms of litigation. And as you can imagine, in addition to litigation in general, especially with groups that have a very strong interest in making sure that they are not found to be liable for what we're saying that they should be liable for, we also have federal agencies that we're dealing with that are not, I'll call it, are not nimble. So these processes that we're going through, I appreciate your patience on this. I know it's not easy. I know all of you are dealing with this on a day-to-day basis. This is your lives. This is your family's lives. And we're moving it along as quickly as we can, but as the system is, the system is. And we're doing the best that we can. I have, as I've told you, I am always ready, willing, and able to sit down with any party regarding a real, viable settlement discussion, and that remains. And I'm hopeful that we will re-engage at least some of the remaining defendants with those discussions, just as of right now, not. I'm always hopeful that, for example, the summary judgment hearing, once that's scheduled and heard, that the result of that hearing will clear the picture a little bit more for parties and maybe incentivize them to sit down and discuss settlement, because that gives one piece of the allegations clarity. And now once you know, okay, this is what the judge ruled here, our exposure is a little bit greater than we thought because we were hoping we could get rid of that, but we didn't. That maybe will incentivize parties to sit down and talk a little bit more. Any questions? Any more questions? Yes?
Court cases that you want us there in the near future?
There is nothing pending right now that where it would be beneficial. Or I guess I'll say it's always necessary to have you there, or always beneficial to have you there, but nothing where the volume of purple shirts in the courtroom will have an impact. If we end up having to go to court to extend the put, that might be one, but I'll communicate with the various representatives and let you guys know if it's something where it would be helpful to have some en masse support as we go into that hearing. Okay. But I do appreciate, and it is not lost on either Judge Smith or Judge Stern when you are there. They understand the gravity of the situation that it has on you and your lives, and they appreciate it, and they recognize what you are sacrificing because of this suit, but also what you sacrificed to actually be in the courtroom on those days. Any other questions? If there are no other questions, other than 2 interruptions for phone calls that I didn't have to answer, we made it through before that phone call, and I appreciate everybody coming out as usual. We will schedule another one in the same way about 6 weeks from now, and we will continue to post things to the website. Like I said, I'll talk to Attorney Hemmendinger about posting his pleadings, and it's either going to be on his website, which I will let you know about, or we will coordinate having another prong for our website for you to look at that stuff. Everybody have a good night. Travel safe.